Well, hello, everyone. My name is Todd Silliman, and with my colleagues Anna Maria Tatova and Claire Gregory, we are pleased to talk with you today about international environmental regulatory trends. Today, we'll be discussing evolving environmental regulations that impact businesses within and across our respective jurisdictions, especially new rules dealing with import and sale of products across jurisdictional boundaries. Despite a pronounced deregulatory trend, there are new and ever-changing requirements in the UK, EU, and US that have major impacts on businesses. Among these are regulations on chemicals, on import of packaging materials, and on import of products that are seen as contributing to deforestation or reducing biodiversity. We'll provide an overview of these in the time that we have with you today. Now, before we start, and by way of introduction, Evershed Sutherland is a global law firm with 75 offices across Europe, the US, the Middle East, Asia, and Africa. We have a leading global ESG practice that includes practitioners across many jurisdictions and disciplines. We issue regular publications and hold webinars on topics that span the entire ESG spectrum. Today's topic is environmental, and we on the panel are environmental lawyers in the EU, UK, and US who work together closely on these issues for our clients. Please allow us to introduce the members of our panel, and we'll start with Anna Maria.
Hello, good afternoon also from my side. My name is Anna Maria Totova. I lead the environmental law practice at Evershed Sutherland, Slovakia, with my additional expertise with my additional expertise in energy and real estate. I have experience of over 20 years, and I advise clients on broad spectrum of environmental matters like protection of air, water, soil, environmental impact assessment proceedings, or waste management. And together with my team, it is either to advise on a complex transaction or a standalone issue. My work spans Slovakia, but also often other European jurisdictions. And I hand over to Claire.
Hi, good afternoon, everyone. Good morning for those in the States. I'm Claire Gregory, I'm a partner, and I lead the UK environmental practice. Much like Anna Maria, my practice is kind of full service. We deal with this kind of standalone advisory work, permitting contaminated land, water, energy. But we also deal with a lot of corporate defence work as well, often defending regulatory prosecutions or permit appeals notices. Now I'll hand you back over to Todd.
Claire, as mentioned, I'm Todd Silliman. I lead Evershed Sutherland's US environmental practice, and I'm co-global lead for our international sustainability and ESG practice. I've been in environmental law for over 30 years, covering all areas, including air, water, chemicals, waste, contaminated sites, and endangered species. My home is in Atlanta, but my work is national and increasingly international in scope. So those introductions, we'll jump right in. And as we do, a housekeeping note, please submit any questions you may have to our Q&A function. We'll either try to answer those today or we can follow up with you afterwards. So our first topic is chemical regulation, and there's a lot of activity going on in Europe and the US in this area. We're going to focus today on PFAS, hydrofluorocarbons, and some other significant bans and restrictions. So perfluoroalkyl and polyfluoroalkyl substances, or PFAS, are found in many everyday industrial and consumer products, as I'm sure. There is a general consensus that these chemicals pose risks that warrant attention. The difficulty is how to address these in a way that is effective and feasible, given that they're nearly ubiquitous and potentially harmful at extremely low concentrations. I'm going to show here a map of the US public water systems in which PFAS has been detected, that is in our drinking water. Maps of every other industrialized country in the world would show essentially the same thing. In the US, EPA has not banned PFAS, but some states are beginning to do so. EPA has issued a number of regulations aimed at PFAS, and most notable, I'm going to mention a few of these. One is in 2024, EPA designated 2 PFAS substances, PFOA and PFOS, as hazardous substances under CERCLA, the effect of which is that EPA can issue orders for cleanup, and parties that perform cleanup under an EPA order or otherwise can sue others to recover their costs. A further consequence of this is that PFAS now falls within the scope of phase 1 environmental site assessments under the ASTM standard, meaning that PFAS risk is entering environmental diligence for commercial real estate in a more formal way. And currently, the rule that designates these 2 PFAS substances as hazardous has been appealed to the DC Circuit, and the Trump EPA just this month told the court that it intends to defend those designations. Also in 2024, the Biden administration established national drinking water standards for 6 PFAS chemicals under the Safe Drinking Water Act. This not only affects public water systems, but drinking water standards are used as benchmarks for remediation of surface water and groundwater in the federal and state levels. So it has broad implications. And just a few days ago, EPA announced it was pulling back the drinking water standards for several of those chemicals, meaning it's going to revisit them. That doesn't mean there won't be standards, but it's revisiting them. And also important to notice that more than 20 states have enacted their own drinking water standards for PFAS, some of which are even stricter than the federal. Last phase to PFAS, the Biden EPA issued a rule under TSCA Section 8 requiring companies that manufactured or imported PFAS containing articles between 2011 and 2022 to report. The reporting period for most businesses has now been extended to begin in April and run to next October. And so to sum up on PFAS, the regulations affect businesses that have PFAS in their supply chains or who are looking to buy or lease property where PFAS could be present as a result of current or legacy activities. So it's a broad impact. Switching now to hydrofluorocarbons, this is another issue that's front and center. HFCs are used in AC units, chillers, and other equipment as a refrigerant, in insulating foams and aerosols and other applications. And HFCs proliferated beginning in the 1990s as an alternative to ozone-depleting chlorofluorocarbons. The problem with HFCs is they contribute to global warming at many times the level of carbon dioxide. And the American Innovation and Manufacturing Act, or AIM Act, mandated the phase down of manufacturing and import of HFCs to the United States, and the bans on many of these HFCs went into effect in January of this year. Others are coming down the line. The deadlines are chemical dependent and use dependent. There are further deadlines for when products that were imported or manufactured before the deadline have to be distributed or installed. So it's important to understand and be aware of which chemicals and which products, types of equipment these deadlines apply to. The DC Circuit has upheld the bans, and the Trump administration has not yet announced any intention to pull them back. We also should know that there are several states, most notably California and Washington, that have their own HFC deadlines that are even stricter than the federal. Lastly, on chemicals, I just want to mention the phase outs of trichloroethylene, tetrachloroethylene, and chrysotile asbestos in the US. EPA announced all of these phase outs in 2024. The TCE and asbestos bans have gone into effect for most applications. The PCE ban has been paused temporarily. I mention these because these are all products and chemicals that are widely used and have been for decades. So there are many supply chains out there. But the other broader point is that they're indicative of the EPA's ongoing assessment of chemicals under the Toxic Substances Control Act. So generally speaking, we're not seeing a rollback in the chemical regulatory under TSCA and otherwise to the degree that we are in certain other areas of environmental law. And this has implications, again, for products going in and out of the United States. So now I'm going to send it over to Anna Maria to talk about chemical regulatory developments in the EU.
Thank you, Todd. Regarding PFAS, we have already for more than 2 years extensive discussions on PFAS. As 5 European countries filed a proposal to the European Chemicals Agency to restrict the manufacture, use, and sale of over 10,000 PFAS substances under the REACH regulation. After 2 years of revisions of this proposal, we have the final wording. It is now available on the webpage of the agency, and the scientific evaluation is planned to be final by the end of this year. So the decision should be filed in December, and draft opinion, so the decision in writing, is expected for March 2026. After that, there will be the consultation period open for 60 days for everybody, and it will be conducted on the survey basis. It means that the stakeholders have the possibility to bring their comments. However, there will be defined questions by the agency which are relevant for the agency, so only these are to be answered and no attachments will be accepted. This evaluation now concerns 14 different sectors like cosmetic, textiles, food packaging, transport, and also important is electronics and semiconductors. And except of that, the 15th sector is the PFAS production manufacturing sector itself. We have already now some restrictions for PFAS under the REACH. As an example, it is the PFHXA, which is now in place approximately for 1 year. And this restriction prohibits the sale and the use of this substance in consumer textile products, as waterproof jackets, in food packagings, or in some in skincare products, and also in different ones. This restriction does not apply to high-tech applications like semiconductors, but as the agency already announced, it is very likely that there will be implemented many new restrictions for different PFAS substances with the new regulation, which will be general governing PFAS. In Europe, we have also information and reporting obligations for substances on the candidate list of very high concerns, which you can see on the slide. And what is important to mention, companies which are active on the European market in different countries have to bear in mind that member states in the European Union have the authority to adopt their own measures, and some countries like Denmark or France, for example, also took this opportunity. I would like to draw your attention also to a recent court case. It is from Italy, from northern Italy. The judgment is quite new. It's from June 2025. It is only the first instance decision, therefore not final. But it's important to know that it's about a PFAS manufacturing factory which produced PFAS already since 1960s. And in the court in the decision stated that the company was aware of the environmental risk of the PFAS production, and continued its operation without adequate environmental measures, and also that the managers of the company knowingly discharged toxic substances into the environment, and as a result, there is the conviction of 11 managers of the company with prison sentences between more or less 3 to 18 years, and also very high fines were imposed to the company and also to the managers, and compensation was awarded to civil parties. This decision is very important, and it clearly demonstrates that company must pay attention to PFAS, and not only PFAS, but chemicals as such, as their use and inefficient and insufficient compliance can lead to serious negative consequences for the company and also for the managers. And finally, I will give you some short insight on the regulation on hydrofluorocarbons in the EU. We have the F-gas regulation in Europe. It is applicable since March 2024 and it establishes a binding gradual reduction of HFCs in the EU regarding production and consumption. The goal is to have the complete phase out by 2050. There are also targeted bans for specific products. For instance, it is prohibited to place on the market products where technically and economically viable alternatives exist. It is like for refrigerators, air conditioners, heat pumps, or aerosols. And the effective dates for these particular products are depending on the equipment, and it's between 2027 till 2035. And I will now hand over to Claire, who is going to present the current situation and approach in UK.
Thanks, Anna Maria. Okay, so diving right in. Post-Brexit, the regulation of chemicals in the UK has undergone quite significant changes. Upon leaving the EU, the UK established its own regulatory framework, known as UK REACH, which came into force 1st of January 2021. So it's been in place a while now. Initially, it was a direct copy of EU REACH, but we've since started to see some divergences. It applies in England, Scotland, and Wales, but not in Northern Ireland due to the Windsor framework. The EU REACH still applies in Northern Ireland, so we've got complex issues just within the UK itself. While UK REACH retains some the core principles of the EU REACH, namely registration, evaluation, authorization, and restriction, we are starting to see some key differences emerging. One, the regulator is different. ECHA obviously manages EU REACH. UK is managed by the Health and Safety Executive here. So as such, we don't have, UK REACH doesn't have access to ECHA's database for data sharing, so separate submissions have to be made. In terms of the SVHC lists, EU REACH has, I think, 247 listed substances as of January this year. UK has not updated its list since January 2021, so we are lagging somewhat behind, and the UK is certainly seen as far less proactive. In terms of PFAS, the UK is taking a much more phased approach to restricting these harmful substances rather than imposing a blanket ban, which is what's being consulted upon in Europe. UK government believes that this will give businesses time to adapt and prepare, but there has been a lot of criticism and a lot of NGOs believe this is insufficient. So at present, PFAS are regulated under UK REACH. And I guess in terms of key developments, we've only really seen a few limited bans, and actually these were banned largely under the EU legislation, the ban under POPs regulations. In the UK, we've had no new bans since 2021. Unlike the EU, we've not banned any additional PFAS subgroups since Brexit. And only 2 PFAS are currently restricted under UK REACH, although there are others listed as substances of very high concern. Again, we can see a difference in sort of drinking water standards. At present, England has no legally binding PFAS limits in drinking water. It only has guidance, albeit that has been updated recently. Scotland was starting to see adopt stricter standards more aligned with the EU proposals. There have been some recent bans in relation to firefighting foams, and use of PFOA has now been banned. It was previously permitted under very limited circumstances. But I mentioned this more because obviously it's a development with PFAS, but we're starting to see a growing regulatory focus on PFAS being found in soil and groundwater. And we're increasingly seeing testing requirements for operators holding environmental permits, with a big focus on those sites that are either known to have used PFAS firefighting foams, so MOD sites, chemical sites, major industrial sites, or those sites that actually produce PFAS itself. We're currently working for a company that's being investigated in relation to a site that is potentially going to be designated as contaminated land for the PFAS present. And it'll be really interesting to see how this develops, because it will be the first site in the whole of the UK that's been designated as PFAS contaminated. It'd be quite interesting to see how this may trigger wider regulatory reviews and certainly start to impose perhaps set remediation and obligations across other sites. And I'll hand back over to Anna, I think, to take us through the EPR.
Yes, now we will change the topic. It will be, we will talk about the extended producer responsibility, mainly regarding packaging in EU, UK, and US. And obviously, the reason is that a very big part of waste generated worldwide comes from packaging. In the EU, the extended producer responsibility is long-standing standard. It's known for decades. It's a key environmental policy tool to make the producer accountable for the entire life cycle of the product, not only packaging. Different products are also covered by the EPR, like electronic and electric equipments, batteries, end-of-life vehicles. The new decision of the EU is to introduce the EPR also for textiles. Probably it will be in place within the next 2.5 years. And also it is important for businesses operating in more countries in the EU that some countries have own systems. For example, textile already in place in France, waste tires, waste oils, or even non-packaging like paper leaflets. So if you're entering any European market or within the EU, except of these common EPR systems, please check if there is a specific one for the particular country. Now we will focus on the packaging. As in the EU, we have a new packaging and packaging waste regulation. This regulation replaces the previous directive from 1994, and it will apply from August 2026. However, many obligations will be introduced later in the time. The reason why it is the change from the directive to the regulation is that it is necessary that the approach is more harmonized, because up to now, every member state had the possibility and the flexibility to decide how to reach and achieve the objectives. And now this should be on one system and very the same in the whole EU. The regulation covers the whole supply chain, so from the manufacturer over every single stage of importer or any kind of distributor, and also the logistics service provider. It is important also for businesses which are operating outside of Europe but delivering packaged goods or packaging as such to the EU, as the packaging must fulfill the standards which will be introduced by this regulation. The new approach shifts the focus from the producer bearing mainly the financial responsibility, so paying fees for their packaging, but not really caring about the packaging as such, because there were only few additional obligations. So the result of this shift is, for example, the obligation of minimizing the packaging, which means that some packagings will be completely banned, just like small shampoo bottles in hotels or single-use plastics. And also the obligation to minimize the volume and weight in a way just like minimizing the empty space in the packaging, or by not using packaging chips. The next obligation which will come is the obligation to reuse and refill. There must be introduced new reuse systems. And as you can see on the slide, there will be some obligations, very specific and concrete obligations for transport packaging or packaging within a group. The next obligation is the recyclability, and also the obligation to use recycled content. So on one hand, the packaging must achieve specific recyclability performance classes. For example, under 70%, it will be not possible to place on the market such a packaging. And on the other hand, the minimum recycled content must be used. Also, there will be mandatory industrial compostability for some kind of packagings like tea or coffee bags or capsules. The labeling, which is now voluntary, will be obligatory. So it will be harmonized labeling via pictograms for all packaging, and additional information for consumers will be provided via a QR code. And the last main obligation, which will come with the new regulation, it's the restriction on some chemicals in the packaging, or the like for PFAS. There will be set limits, and the packaging will be banned or cannot be brought to the market if there is a higher PFAS content. And the total amount of heavy metals, specific heavy metals, also cannot be, must stay under the limit of 100 milligram per kilogram. And now I will hand over to Claire regarding UK.
Okay. So quite similar to the EU, the producer responsibility obligations, packaging and packaging waste regulations, bit of a mouthful, 2024 came into force earlier this year on the 1st of January. And they do mark a major reform really in the UK packaging laws. They repeal the interim data reporting rules that came in 2023, and they will fully replace the 2007 packaging waste regulations from 1st of January 2026. The change is part of the UK's extended producer responsibility scheme, which the aim is to shift the financial burden of packaging waste from local authorities to producers. So under the new rules, producers are responsible for the entire life cycle of the packaging they place on the market, from collection and recycling to final disposal. And it could potentially triple packaging waste costs for some retailers. So it's going to mark a massive change, and it is coming in very, very soon. Just like the EU, the aim of it is to encourage eco-design and recyclable packaging, to better implement polluter pays principle, support the circular economy by shifting all the costs to producers, and any funds that are collected will be distributed to local authorities to improve waste management. So in terms of who is affected, it impacts small and large producers. A business is a small producer if it has a UK presence, has a turnover of more than 1 million per year, and imports or supplies over 25 tonnes of packaging annually. Large producers are those with a turnover of over 2 million that handle more than 50 tonnes of packaging, and there will be additional reporting and fee obligations for these larger producers. In terms of the obligations, all producers must register, and that's via a government online portal. Large producers have to report their packaging data twice a year, in April and October. By the 1st of December this year, producers have to report where their packaging is supplied across the UK. And then shortly after, producers are going to be expected to meet recycling targets based on the particular type. And then disposal fees are due to start next month, and the fees will be based on the packaging type and the recyclability. In terms of how this differs from the EU, there's a much greater emphasis on data reporting and transparency here in the UK. There's no need for mandatory sorting labels on packaging as opposed to the EU. And unlike the EU, EPR in the UK for textiles, footwear and sports equipment is not yet mandated, but consultations are underway. As you can see, I think for businesses trading across both the UK and the US and EU, it's going to mean increased administration costs and increased administration burden. There's going to be a need to, assess and audit your packaging flows across the continent, and then a need to understand the various different rules, different definitions perhaps of who is the producer, different compliance deadlines and different reporting requirements across the entire continent. And obviously it's all coming in very soon, the UK next month. With that, I'll hand over to Todd.
Claire, so extended producer responsibility has made it to the US. This is a trend that really began overseas and has made its way here, not federally, but in a number of states. Thus far, 7 states have passed EPR legislation. EPR bills have been introduced in 9 others. The laws apply to companies who send single-use packaging into the relevant state. Unlike the EU, these are not direct bans or mandates on packaging type and design, but rather, measures to incentivize packaging reduction and reuse through, fees. The state EPR laws all resemble one another and require companies to register with the state designated producer responsibility organization, to report annually the packaging they're sending into the state, and to pay fees for those packaging materials. There are, as is the case in the UK and EU, there are exemptions for companies whose aggregate annual turnover or income is below certain amounts, but know that these thresholds are quite low, sort of in the $1 million range. So most companies, or many, who are operating at a significant level are going to be caught in this. There are, of course, penalties for non-compliance, and those can be significant. There are different fee rates for each base material category. So determining your fee can be a complex exercise and one involving, interpretation. So it's important to be sure that you're consulting with your experts and counsel. Oregon, Colorado, California are all leading the way in this. The deadlines have already passed for the first annual reports in Oregon and Colorado, and the deadline for California reporting is later this year. The first fees are due in Oregon this year, in Colorado in 2026, and in California in 2027. So we should expect to see the number of EPR laws in the US to increase. This will contribute to compliance costs and will drive behavior around packaging reuse and waste minimization. So with that, I'm going to turn it back to Anna Maria to talk about timber import and deforestation regulation.
Thank you. In the EU, we have a place so-called deforestation regulation, which aims to reduce the global deforestation, gas emissions, and global biodiversity loss. This regulation was published already in 2023 and is expected to come into effect on the 30th December 2025, so in few months for large and medium companies, and a half a year later for micro and small enterprises. However, it is important to note that just last week, the European Commission announced that a further 1-year postponement is being considered. So the application was already postponed for 1 year, and now it's another consideration to postpone it again. But there is no formal decision yet on the postponement. So we advise to monitor ongoing development and ensure the readiness for the applications as originally scheduled from the beginning of the next year. Should some news will come, we will definitely inform you. So the regulation applies to businesses which are selling certain goods to the European Union. And this includes also companies which are not based in the European Union, but are delivering the goods to the European Union, and also companies who are exporting goods from the EU. Businesses that place cattle, cocoa, coffee, soya, palm oil, wood, rubber, or their derived products on the European market or export them from the EU are required to ensure that the goods are deforestation-free. They comply with the laws of the country of origin, and they are covered by a due diligence statement. It's not only these commodities, I said, but also the derived products are covered. I would like to stress out that also, for example, paper, books, newspaper, or chocolate must comply with this regulation. The complete list is in the attachment of the regulation. To meet these requirements I just mentioned before, companies must establish and maintain effective due diligence system, collect and retain relevant data on their products, such as its source or the geolocation, and also electronically register and submit the due diligence statements to the European traces system, which is operated by the European Commission. And this must happen before importing or exporting these goods to the EU or from the EU. If you need some additional information regarding this registry, you can find them definitely on the homepage of the European Commission, or we can navigate you. I will now send to Claire, who is going to address the UK approach.
So yeah, in the UK, we have, well, we don't have it yet, but what will be known as the UK Forest Risk Commodities Scheme, the FRC scheme. It's a forthcoming regulatory framework, and it's designed to prevent the use of illegally produced commodities linked to deforestation in UK supply chains. It's part of commitments made under the Environment Act 2021. And so it's not yet enforced because it requires secondary legislation, but it is expected to have significant implications for businesses once implemented. Unfortunately, we don't know when this is likely to be come into force, subject to the government's decision on that. I think when the Labour government came in, they've not quite committed to how they want to deal with this. So a date for it coming through is yet to be determined. And given the recent delay to the EU scheme, it seems likely that alignment may be sought anyway with that. Essentially, once it is enforced, it will require large UK businesses to conduct rigorous due diligence on their sourcing of forest-linked commodities. The UK scheme is narrower in scope than that of the EU, and it will focus only on illegal deforestation, whereas the EU bans all deforestation-linked products, regardless of their legality. So it's sort of baby steps, really, for the UK. Again, the initial focus is slightly different here. It will focus on 4 high-risk commodities, so non-dairy cattle products, so beef and leather, cocoa, palm oil, and soy. In terms of who it's going to apply to, all businesses operating in the UK with a global annual turnover of 50 million. Those companies who are using more than 500 tonnes per year of any of those regulated commodities, and subsidiaries of in-scope companies will also be covered. Although businesses below the threshold may apply for an exemption, but it won't be automatic. In terms of requirements, the principal one is businesses must not use illegally produced forest risk commodities, including their derivatives. Companies must implement a due diligence system to verify the legality of sourcing, and you must also report annually and publicly on these due diligence efforts. So parts of the report will be published to ensure accountability. I guess there is a bit of divergence from the EU's broader approach, so it might create some compliance challenges for companies operating in both markets. I guess while the law is uncertain in that we don't know when it's going to be implemented, but we know what it's going to ask us to do, it would be sensible to take this time to perhaps consider carrying out risk assessments of the commodities in your supply chain, engage with your suppliers, consider including deforestation clauses in those contracts, establish the due diligence system required to verify the products in use, prepare for annual reporting, develop those processes and be ready to submit those public-facing reports on compliance. And I guess finally, and that's something we can help with, is monitor for legal updates as to when the EUDR and the UK FRC are likely to come into force. And I'll hand back to Todd.
Thank you. As you all alluded to, this affects companies sending products into or out of the UK and EU. In the US, we do not have product-directed deforestation regulations yet. But these regulations will affect US companies if you're sending products into or out of the EU or in the future as to the UK. So manufacturers and suppliers need to be aware of these if they're going to be engaged in that activity. Well, that concludes today's presentation. Unfortunately, we don't have time to answer any questions that have come in, but we're happy to follow up with you afterwards. Any of you who have asked questions, or we invite you to reach out to us if anyone has further questions, desires clarifications, or wants to discuss any of these matters with us. We're always happy to do so. We appreciate your attendance today. We hope you found it informative, and we wish you a great week ahead. So long.